In the middle of your trial, during a break, the judge speaks to your attorney and recommends highly that you settle your case. Do you have to go along with the judge's recommendation? Do you have to agree with what the judge suggests? You want to know the answer? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a gorgeous day today here, and I had a few minutes to share this great information with you. So let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. Your case goes all the way to trial. It's taken you 3 years to finally get to trial. You are now at trial. You're a week and a half into your trial. You've got another week and a half to go. And during the middle of the proceedings, the judge decides to take a 10-minute break. During that break, the judge calls your attorney up to the bench. And now, typically that's not done. Typically, when the judge calls an attorney up, he expects both attorneys, both sides to come up so they can hear exactly what is being said. However, the judge only wants to speak to your attorney. Why? Because he wants to get settlement discussions going again. He tells your attorney that in his opinion, you are losing your case. He says to your attorney, listen, I think it would be in your interest and your client's interests to go ahead and start negotiating again to try and get rid of this case, to try and settle this case. And now your attorney comes back to you and tells you exactly what the judge just said. Do you have to go along with that? Do you have to agree with what the judge has just said? The answer is no. You don't have to agree with it. You don't have to go along with it. You don't have to abide by the judge's suggestion or recommendation to start settlement negotiations again or to enter into settlement discussions. Now, on the other hand, there may be a lot of validity to what the judge is saying. The judge has quite a bit of experience handling these types of cases. The judge tries these cases all the time. The judge knows that there is always uncertainty when going to a jury verdict, and the judge is making a recommendation. Why? Because he doesn't want you to walk away from this court, from this case, with nothing. He gets the sense, he gets the impression that your case is going downhill. So he makes a suggestion and says, Counselor, if I were you, I'd start settlement negotiations and try and move this case as quickly as possible. He then calls the defense attorney up, and now he tells the defense lawyer, hey, listen, if I were you, I'd try and negotiate this case and settle this case sooner rather than later. Now, why would he do that? Because he tries to put pressure on both us as the plaintiff and the defense to try and get them to realize that there are significant risks about letting 6 members of the community decide whether you are slightly more likely right than wrong, that what you are claiming is true. If the jury ultimately decides that you are slightly more likely right than wrong, now during a jury verdict, you are likely to get a verdict in your favor. But just because a jury rules that the doctor was careless and violated the basic standards of medical care doesn't mean that you're going to get the ultimate result, meaning a substantial verdict in your favor. They could give you a lot, they could give you a little, they could give you somewhere in between. And if the jury ultimately gives you a tremendous amount of money as compensation for all the harms and losses and damages that you incurred, guess what? The defense will in all likelihood appeal that verdict. So now let's get back on track. The judge has recommended that you try and negotiate this case and try and settle this case now. Do you have to agree? No, you don't have to agree. In fact, you may feel totally different. You may feel fantastic right now. Why? Because your attorney just finished cross-examining the other side's expert, and he tore him apart. Now, you feel great. The defense feels horrible. And now you're thinking, why should I go ahead and try and negotiate? Why should I try and settle this case when you are winning your case? Well, the judge doesn't see it that way. And you should also know something else. Just because you are at a particular high right now, after listening to cross-examination by your attorney, I guarantee you that during the course of your trial, you are going to have a series of highs and lows. That's exactly what happens. Some days you will feel you are on top of the world and you are invincible, and other days you're going to think that you are losing your case and nothing that you and your attorney can do are ever going to pull you out of the dumps. That's exactly what happens. So at this particular moment, you totally disagree with the judge. You tell your attorney, under no circumstance am I going to settle this case. I want a jury to come back with a verdict. You should have this discussion again when you are now on the opposite end of that curve, and now you're wondering, oh my God, how am I ever going to win this case? So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.